Back with you tonight, you're on In Focus, and the conversation continues. The introduction of the second police docket in the Senzo Meyiwa murder trial, throwing a spanner in the works, or a cat amongst the pigeons, as they say. This prompted Advocate Zandile Mshololo to ask the court for a postponement for her cross-examination to allow her to familiarise herself with the new docket. It accuses singer Kelly Khumalo and 6 others of being prime suspects in the 26th of October 2014 murder of Senzo Meyiwa. The same docket was previously only disclosed to Advocate Tefo and not the prosecution. Proceedings have been postponed until Monday. Legal expert Advocate Modidima Mannya joins us now to help us make sense of its implications. Advocate, good evening, and thank you very much for your time and for joining us tonight here on In Focus. Does this docket, or the existence at least of 2 dockets, violate the defendant's right to a fair trial?
Good evening, and good evening to your viewers. Let me explain this way. When a person appears in a criminal trial, that person has a right to receive a disclosure of the documents upon which the case is based, to the extent that they are not privileged and may be disclosed. And I do not think that in the mind of the state, this second docket was relevant to the charges put against the accused. And probably for that reason, they didn't see the need to disclose it. But it featured prominently in the cross-examination. And of course, it seems like it reached a stage where it had to be disclosed and was disclosed. Whether it causes prejudice to the accused or not will depend on what the content thereof is.
And what does then the judge do? How does the judge treat this docket in the matter?
Look, this docket is not before the court per se. Let me probably explain. It is obviously a bit unprecedented to have 2 dockets in the same involving the same incident. So in real terms, it's probably all of us get sort of shocked and a bit surprised that there would be 2 dockets. But I also don't think that the existence of the 2 dockets mean anything more than the fact that there may have been 2 investigations and 2 investigation teams in the same matter, which is something that probably in time we'll get to understand how the police got to have 2 investigations, because it doesn't seem like the 2 dockets were compiled by the same police officers.
Yeah. It does indeed create a bit of a situation here, because you've got a version of events that is on one docket that is not relevant to the current accused. Yes,
you see, the process is that the police conduct an investigation, and they are at the conclusion of their investigation, they hand over the docket to the National Prosecuting Authority, which must determine first whether any criminal trial should be initiated, and if so, what the charges should be. The obvious question is whether the National Prosecuting Authority, upon receipt of a docket, must just charge as per what the police think should be the charges, or must just charge because the police think there must be a charge. I don't think so. You know, there is a constitutional obligation on the National Prosecuting Authority to take rational decisions, lawful decisions, when it initiates prosecutions against people. So I guess that if the prosecutors are of the view that despite the content of the docket, they are not satisfied that a criminal trial should be initiated, they shouldn't do so, simply because the police have put the docket before them.
So what do you make then of the issue that is being raised by the defendant? Firstly, let's get here. Does the defense have a right to bring this docket into the trial?
Well, yes, to the extent that it is relevant. That's why I'm saying I think the difficulty is we don't even know what the content of that docket is. We get a sense that there is a proposition that it suggested that the people who were in the house be charged. That's as far as we know. But what the actual content is, we don't know to be able to make an informed comment on it.
Yeah, and that brings us very nicely then to the next question. Does the NPA have a right to charge people anyhow, because the contention made by Advocate Mshololo defending accused number 5 is that there is an administrative way of discharging this decision, and accused number 5 needs to be informed about the reasons about the decision taken not to charge those in the second docket.
Yes, even if to the extent that he has that right, the question is what is the correct procedure to get those reasons? Let me put this thing this way. This is an 8-year-old matter, and I think everybody has been saying, why is it taking so long? Will it ever happen? One of the things that could have happened is that an inquest could have been held, which could have probably determined who should be charged, as has happened in a number of instances, and that was not done. The second option is that when a decision was taken not to charge, those who had an interest could have reviewed that decision either by approaching the national director, because the decision was taken by the Director of Public Prosecutions. The NPA Act makes provision for a review of the decision of the Director of Public Prosecutions by the national director. And the national director would have considered and said, okay, I think the director is wrong, or I confirm the decision of the director. Or people could have even approached the court on review to review the decision not to charge. Now, none of that has happened. What we see now is an issue that has been raised to say this is how it impacts. But you must remember that the decision of the prosecutors not to charge stands until it's set aside in law.
So does the judge have discretion here how to deal with the second docket? Does he have a considerable discretion in determining what happens to the second docket?
The judge has got no business to do with the second docket, and I think he has said pointedly that the court doesn't have the authority to order the NPA on who to charge, who not to charge. What the judge will do, to the extent that the docket features as part of the evidence, he will consider that. But there's no way that the judge is going to say, well, now that this docket is before me, I've seen it, and I direct the NPA to charge so-and-so. He cannot do that. Neither can he say at this stage that because I see this docket, I don't think these people were correctly charged. They have been charged. They have pleaded. At the close of the state's case, the defense has got a right to bring an application for their discharge. If that is not granted, they would have to give evidence. And at the end of everything, then the judge will decide whether to convict or acquit them.
Yeah. Now, if you are faced with a similar matter, how do we then streamline this process? I mean, if you are either for the defense or you're for the NPA, to resolve the case in a more efficient process?
Well, as I say, one of the things that should have been done in the light of, and I don't know when people became aware of this docket, but even at this stage, I think you could still make representations to the National Director of Public Prosecutions. I think the request to the court to stop the prosecution should probably have been directed to the National Director of Public Prosecutions.
Advocate Modidima Mannya, I appreciate your time. Thanks so much for that analysis and intervention this evening. That's legal expert Advocate Modidima Mannya. When we continue